Happy Monday, and welcome to another episode of Cases That Should Have Gone to the Supreme Court of Canada, but didn't. Today, we're talking about the role of Crown Counsel. Cases that should have gone to the Supreme Court of Canada, but didn't. In Saskatchewan, a lawyer who worked for the Crown Counsel in Saskatchewan also had a side job dealing with civil plaintiff work, essentially advancing lawsuits. And in the course of their civil plaintiff work practice, this lawyer advanced a lawsuit against a professional who was facing discipline from the disciplinary body, and the Crown Counsel lawyer advanced the lawsuit on behalf of somebody who was alleged to have been harmed by this professional in the course of their professional capacity. At trial, the professional argued that the Crown Counsel acted outside the scope of the permissible outside of Crown Counsel work that they were doing, and essentially in a conflict of interest. Because this person was facing some sort of a prosecution, it was unfair for somebody who was a Crown Counsel working for the government, the investigating and prosecuting body, to also initiate a civil lawsuit on behalf of a plaintiff, that this was a conflict of interest. And this case raises very important issues. In law, we give Crown Counsel a little bit more leeway as far as their status. There is some immunity that Crown Counsel have with respect to their professional obligations from being sued. There are some exemptions given to Crown Counsel in relation to paying professional fees and for insurance and memberships with the law societies. And all of those issues are things that justify why Crown Counsel has a very insular role. But when Crown Counsel acts in two different capacities, it raises concerns about the blurring of the lines between those two capacities. Information learned or used in a criminal prosecution perhaps being learned or used to advance a civil claim. And especially when a civil claim is predicated on a contingency fee agreement, it may also make the Crown Counsel more likely to want to advance a criminal prosecution against an individual or advance some sort of an administrative prosecution that they're handling against an individual because it may benefit the civil claim. This is why, generally speaking, Crown Counsel don't have side jobs. So this case raises a very important issue that the Supreme Court of Canada should have addressed about the scope of the role of Crown Counsel. We've seen the Supreme Court of Canada deal with cases involving the scope of Crown's immunity from lawsuits in circumstances before, where they determined that Crown Counsel don't have absolute immunity to being sued like judges might, and that there are options in which Crown Counsel could be held civilly liable, but also putting limits on in circumstances in which Crown Counsel can act outside the scope of their role serves important public goals. It also gives confidence to members of the public that they aren't going to essentially be punished by the state through the civil process because of the dual role that a Crown Counsel member is playing. And if there's any appearance of impropriety, this should also be within the scope of the Crown's duties, something that should be avoided, because Crown Counsel are supposed to be acting not in the interest of securing a conviction or a particular outcome, but merely presenting the truth to the court so that the truth can determine the facts of what happened. They shouldn't be advancing civil claims unless they are completely unrelated to the scope of their role in the prosecution service. And unfortunately, the Supreme Court of Canada really missed the opportunity to constrain the side gig empire that people seem to be building these days, and specifically when it comes to the role of Crown Counsel, so that the public can have more confidence in the administration of justice. At the end of the day, this was a case that raised important issues related to public confidence in the administration of justice, and unfortunately, the Supreme Court of Canada missed the opportunity to really chime in on something that could potentially lead now to conduct that would call the administration of justice into disrepute. It would be nice to see the Supreme Court of Canada put some pretty clear limits on this, and hopefully law societies take notice and impose their own obligations to ensure that nothing is done that would undermine confidence in the justice system. Cases that should have gone to the Supreme Court of Canada, but didn't. Thank you for tuning in to another episode of Cases That Should Have Gone to the Supreme Court of Canada but Didn't. I'm Kyla Lee at Acumen Law. Thank you to Brazen Bull Creative for putting together these videos. Please like, subscribe, and share with your friends.